All right, thank you for joining us, everyone, for this quarter's Compliance Bootcamp webinar, Understanding Wellness Plan Compliance. An expanded version of the presentation slides will be emailed to all of you by tomorrow. At the bottom of your screen, you'll see several widgets for your use during the presentation. For example, if you have a question, please click the purple Q&A icon to the left. At the end of the session, the yellow certification icon on the right will become active for you to download your SHRM and HRCI credits. Speaking today is Dan Cooperstein, Senior Vice President of Compliance at Corporate Synergies. Corporate Synergies is a national insurance and employee benefits brokerage and consultancy where Dan is a respected thought leader on healthcare reform. He has published many articles and videos on the Affordable Care Act and other laws and regulations, which can be found in the Knowledge Center on corpsyn.com. That's corpsyn.com. Dan is an ERISA attorney with experience in a broad array of sophisticated employee benefits and labor and employment matters, including the ACA, COBRA, HIPAA, and GINA-Compliant. At this time, I will turn it over to Dan.
Great, thanks, Dina. And welcome to today's presentation, Decoding the Final EEOC Regulations on ADA and GINA-Compliant Wellness Plans. Of course, the big goal for today, and what we want you to all take away from today's webinar, is to get a better understanding of the new final wellness plan regulations that came out this summer under both the ADA and GINA. But in order to understand how that development really impacts your organization, we really need to put that into some context. So we broke this presentation up into different sections. In the first section, we'll be talking about the big picture of wellness plan regulation in the United States, with the goal of getting a basic understanding of the major or most significant laws and regulations applicable to wellness plans. And I'll refer to those throughout today's presentation as the big three. As well as we're going to take a look in this section at a timeline of big developments as well as recent developments, so major things and some recent things that have happened. And then at the end of this first section, we'll give you some key takeaways that you can use for your benefits department or HR department on each of these three big rules. And then in the next section, we're going to really focus in on wellness incentives and to really understand how the new incentive structures work under the final EEOC regulations. We're going to first look at the HIPAA rules on wellness plan incentives, and then we'll look at the new rules on wellness incentives, and then we're going to give some examples of compliant and non-compliant wellness plans that you can kind of take with you and use as guides. In the third section, we're going to focus in on confidentiality and disclosure, as well as talking about some of the things that employers are doing out there to make sure that the information remains confidential that's in the wellness plan. And then we're going to focus on a recent decision that discusses, among other things, the gatekeeper rule. It's called the Bona Fide Benefit Plan Safe Harbor, and some other issues that are kind of hot topics right now. And in fact, we had some very recently occurring late-breaking news in that area, so we'll talk about that as well. And then the fifth section, we're going to talk about some other laws that, outside of the big three, that you need to be aware of, the ACA, COBRA, and the tax code, and how those things can, some of those compliance considerations that you need to think about when you're reviewing your wellness plan and designing your wellness plan. And then finally, we'll just discuss briefly some recent compliance developments that we're watching and that we think that you should be watching too. So with that being said, let's go ahead and get started. This is really the face that whenever I start to talk about the new requirements that are happening on wellness plans and all the regulations that are out there, this is what I imagine most of the HR and benefits managers' faces look like when they're on the other side of the phone. Because really, this is really a very confusing area for many. In particular, you have so many different varieties of wellness plans out there, from your informal meditation class in the break room with no employer-sponsored incentives at all, to your hypercharged 10,000 step a day walk, take a blood test for nicotine, get into a healthy BMI range, or get a surcharge type of wellness plan. So there's a lot of different types of wellness plans, many different ways that they interact with different kinds of health plans and different health plan options, and many different laws that apply to wellness plans, from state wage and hour laws to federal privacy laws to the tax code. There's just a broad spectrum of things that we could be discussing today. And since we really only have 1 hour, we're going to focus on the most important of these rules and laws, the major ones that impact most wellness plans in this country. And those major pieces of legislation are HIPAA, the ACA, the Affordable Care Act, the Americans with Disabilities Act, or ADA, the Genetic Information Non-Discrimination Act, or GINA, ERISA, the tax code, and COBRA. So we'll be talking about those today. And before we kind of go into a lot of the detail today, I thought it would be good to give 2 helpful timelines so that you can kind of see both the big picture, we'll take a big step back at wellness plan regulation and look at how it's evolved in the United States really over the last 40 years or so. And then we're going to focus in on the recent events that you really should be aware of when you're doing plan design or when you're planning to make sure that your wellness plan is in compliance beginning in 2017. So I think it all really started with ERISA. So I think it's good to kind of start there. Of course, ERISA, I'm sure many of you are familiar with it, the major law that affects both health and retirement plans in this country. Really was the first one to apply to wellness plans. In order for a wellness plan to be covered under ERISA, the wellness plan has to meet the following definition of an ERISA plan, which is that there has to be some kind of plan or program established or maintained by an employer for the purpose of providing medical, surgical, or hospital care or benefits through the purchase of insurance or otherwise to participants and beneficiaries. So when you look at that definition of ERISA, you can see how most wellness plans fit into that. And because many wellness plans, you take a medical test, they give you test results, you learn about how you can get healthier. So many wellness plans are covered by ERISA, and the same goes for COBRA. COBRA applies to what are called group health plans, and that really just generally means any kind of plan that's providing medical care. So a lot of employers they just don't really realize that ERISA and COBRA apply to wellness plans, but they do. And so you have to comply with all of those requirements. ERISA, for example, requires a plan document, a summary plan description, a Form 5500. COBRA, as many of you know, requires COBRA notices. It requires that COBRA qualified beneficiaries have certain rights. And the reason why a lot of employers didn't realize that these laws kind of apply is because in most cases the wellness plan is integrated or tied into the health plan, and so an employer is allowed, under the way the rules are structured, to just do one Form 5500 or do one COBRA notice that applies to both the wellness plan and the health plan. However, if you are, as an employer, sponsoring a wellness plan that's a standalone wellness plan that is not in any way integrated with your health plan, then you do need to do a separate Form 5500 filing, and you do have to comply with those COBRA requirements and do a separate COBRA notice and everything else. So it's something that a lot of employers aren't aware of. Now, the next laws that we're going to go into a lot more detail on, so I'm not going to go into a lot of talking about them now, but in 1990, the ADA was signed into law, which protects individuals with disabilities in the workplace. In 1996, HIPAA was signed into law, which covers a lot of things from the privacy of health information to certain non-discrimination requirements with respect to health plans, and we're going to be talking about how that applies to wellness plans in more detail. And then in 2000, under the ADA, the EEOC, which is the agency that administers the ADA, released enforcement guidance explaining what employers can do to have a voluntary wellness plan. Now, it's very general. It just gave some very general things. Explain what employers can do, and it didn't really give employers that much guidance. It was just sort of some very general, like a paragraph that employers could look at. And of course, that's the reason why today they've given us so much more detail. And then in 2006, HIPAA came out with its final non-discrimination regulation that was applied to wellness plans that prohibited wellness plans from doing certain things. And then in 2008, we saw GINA, the Genetic Information Non-Discrimination Act, and there's really 2 titles of GINA. GINA, under Title I of GINA, that prohibits health insurance plans from offering, from discriminating on the basis of genetic information. And Title II of GINA prohibits employers from discriminating against their employees on the basis of genetic information. And as we'll discuss later, genetic information is defined extremely broadly, so it includes a lot of the things that can be disclosed under a wellness plan. And then, of course, as I'm sure many of you are aware, 2010 was a huge year for health insurance and wellness plan compliance, because that was when the ACA was signed into law. And then in 2013, amendments were made to HIPAA under the ACA that expanded the scope of what wellness plans could and could not do. So I'll be referring to those rules that were finalized in 2013 and that became effective for January 1st of 2014 and plan years beginning after that date. I'll be referring to that as the HIPAA/ACA rules, because it's HIPAA as amended by the ACA. And then, of course, most recently this summer, on May 16th of 2016, the EEOC released final regulations under both the ADA and under GINA that really explain how employers can comply with these two laws, and do explain a little bit of how they're to comport and fit in with those HIPAA-ACA rules from 2013. So it kind of gives you a big picture of what's been going on over the last 40 years. And then more recently, we've been seeing, and just looking at the last few years, we've been seeing a lot of activity happening with wellness plans. Of course, like we talked about at the end of 2013, we saw these final HIPAA regulations that were amended by the ACA. And then in 2014, the EEOC began challenging employer wellness plans under the ADA, even in one case where it appeared that an employer had appeared to comply with the HIPAA-ACA regulations. And the EEOC was saying, well, we don't believe that your plans are voluntary wellness plans, and therefore we don't believe that your plans are in compliance with the ADA. And so the most famous case, of course, that many of you may have heard about was the case of EEOC versus Honeywell International, where the EEOC had sued Honeywell, alleging that their incentives were so high and that the way that they set up their wellness plan was structured in such a way that it violated the ADA and was not a voluntary ADA-compliant wellness plan. And the reason why this case was such an outrage to both employers across the country as well as to Congress was the fact that it looked like the employer Honeywell had done everything right. I mean, it looked like that their plan had complied perfectly with the HIPAA-ACA rules. So the EEOC was challenging something, but there wasn't any formalized regulation. So these lawsuits happened between August through October of 2014. That's when these complaints were filed. And then in April 2015, the EEOC did finally release proposed regulations on what an ADA-compliant wellness plan should look like, giving employers, a sense as to how they can design their plans and be in compliance with the ADA. And then in 2015, in October of 2015, so later last year, they released proposed regulations on what a GINA-compliant wellness plan should look like. And the reason why that was so important was because the definition of genetic information was defined so broadly that many legal commentators and others who were designing wellness plans were not sure if a spouse's medical information could be disclosed in a wellness plan, and whether or not that would, if it were to be disclosed in a wellness plan, whether that would be a violation of this genetic information disclosure prohibition in GINA. And the good news from this proposed regulation is that this did allow for spouses to participate in wellness plans, and we'll talk more about that later. And then the big thing that happened at the end of last year was that the EEOC filed a lawsuit against an employer in Wisconsin in the case of EEOC versus Flambeau. And that decision really challenged the proposed regulations. Came out with a decision, it was a district court in Wisconsin. The judge came out with a decision that really kind of went right against the proposed regulations that the EEOC had just released. Of course, in early 2016, February 2016, the EEOC appealed the Flambeau decision, and we're going to be talking a lot more about Flambeau later in the program. And then, of course, in May of 2016, the EEOC released its final ADA and GINA-compliant wellness plan regulations that we're going to be focused on today, and of course reasserted their position against this judge's decision in Flambeau. And then in late May, we received some guidance from the IRS in a Chief Counsel memorandum explaining some tax rules that are important to understand about wellness incentives. And then in June of 2016, the EEOC released a sample privacy notice that employers can use to make sure that their wellness plans comply with the ADA. And then on July 1st of 2016, we received some informal guidance from the EEOC about how you can use wellness incentives in a case where an employer has multiple health plans or multiple health plan options. So a lot of information. We're going to be focusing on a lot of these recent developments throughout the program, but this kind of gives you a sense as to some of the things that have been happening recently. Okay, so let's start our webinar today with what I call the Big Three. And these Big Three rules, of course, are the HIPAA regulation as amended by the ACA, which is the first thing that we'll be talking about. Those rules that became effective in 2014. And then we're going to talk about the ADA, and then we'll talk about GINA, the two new regulations that we just got. So what does HIPAA say about wellness plans? Well, under HIPAA, group health plans cannot discriminate with respect to eligibility, benefits, premiums, or contributions based on health status, medical condition, as well as many other things, claims experience, medical history, genetic information, evidence of insurability. So that's the general rule under HIPAA. And this rule, however, has an exception for certain types of what are called HIPAA-compliant wellness plans. And there's really two main categories of HIPAA-compliant wellness programs that are out there. And we're not going to go into a lot of detail on each of these because, of course, that could take up its own 1 hour long program. So we're just going to kind of cover the big picture here of what you really need to understand about each of these categories. With participatory wellness programs, generally speaking, for those, the rewards cannot be based on a health factor and they have to be available to all similarly situated individuals. The key thing to remember with these participatory programs is that these are the really simple ones, right? These are the ones that allow everyone to participate, let's say in a particular class, or let's say like a yoga or a meditation class that happened in your break room. Regardless of your health status, you don't have to achieve any health status. There's no, let's say if there is a test that's offered through a participatory program, you don't have to do any kind of follow-up to achieve something. And the good news about these types of programs is that under HIPAA at least, there's no cap on the incentives that can be offered. And just to clarify, when we're talking about incentives today, I'm going to be referring to that as both incentives in the sense of positive rewards that an employer can give to employees that are participating in the wellness plan, as well as surcharges. So when I talk about an incentive cap, that if it's at a certain percentage, that's the maximum percentage of a surcharge, as well as the maximum incentive of a reward that an employer could give. And so the real benefit of these participatory wellness programs is that there is no cap on the incentives. The other main category of HIPAA-compliant wellness plans are called health-contingent wellness programs, and there's two main types of those. Those are activity-only or outcome-based health-contingent wellness programs. For these, the reward that an employer gives is based on a health factor, so there is some kind of health standard that is involved. And for those types of programs, employers have to jump through 5 big HIPAA conditions, or 5 big hoops that you have to jump through. And the key thing to understand, the key difference between activity-only versus outcome-based is that activity-only requires participants to perform an activity related to health, such as a walking program, a diet program, something like that. But the key is that there's at least some activity that is involved, and that activity does not require the participants to attain or to maintain any kind of particular health goal. So that's the key thing to understand about an activity-only program. Now, an outcomes-based program is a little different in that, by contrast, the attainment or maintenance of a particular health goal is actually the key defining feature of the outcome-based health contingent plan. So there, for example, you'd have to, a participant would have to, stop smoking or achieve a certain BMI or get certain results on a biometric testing. So let's talk about the big 5 conditions that health contingent wellness plans have to do to comply with HIPAA. And the first of those is that participants have to have the opportunity to earn the reward at least once per year. The combined rewards for all of the programs together under the same wellness plan cannot exceed 30% of the full cost of the group health plan coverage, with a maximum 50% threshold for tobacco cessation. And the way that works is actually very interesting because the tobacco cessation part is just an additional 20%. So if you, for example, you don't have any tobacco cessation component of your wellness plan, then the maximum is 30%, but if you do have a tobacco cessation component, then the maximum incentive is 50%. And that's one of the major differences between the existing rules that we had under the HIPAA and the ACA and the new rules that we got this summer under the ADA and GINA, which become effective beginning in 2017. And those new rules cap it at 30% of the employee-only tier of coverage. So we'll talk a little bit more in a little bit more detail later about incentives, but that's a major difference. So for example, if a tobacco cessation program is involved in a wellness plan that's covered under the ADA or GINA, then the maximum incentive limit would have to be 30% and could not be 50%. So that's a major difference. The third requirement of the HIPAA rules is that the plan has to be reasonably designed to promote health or prevent disease. The fourth requirement is that the reward has to be available to all similarly situated participants and offer a reasonable alternative standard or waive the reasonable alternative standard. Here it's important to note that the requirements differ somewhat for activity-only versus outcome-based plans. And the key thing there to understand is that the activity-only programs, they have to offer a reasonable alternative standard to anyone for whom the initial health standard is either unreasonably difficult to meet due to a medical condition or it's medically inadvisable to attempt to satisfy. So for example, if the participant can't complete a walking program due to a medical condition, then he has to be allowed to meet some reasonable alternative standard or the program can be waived. In the outcomes-based program, the program has to offer a reasonable alternative standard or waive the initial standard for anyone who does not meet the initial healthy standard based on a measurement test or screening. So those are the main differences. And then, of course, the key difference with respect to each of these is that in the activity-only program, plans and issuers are allowed to ask for verification, such as a physician statement or something to that effect, that a health factor makes it unreasonably difficult or medically inadvisable for a participant to satisfy the standard. Whereas, by contrast, under the outcomes-based program, plans and issuers cannot make such physician verification a condition for providing a reasonable alternative standard. And of course, the last requirement is that the reasonable alternative standard or the waiver of that, it has to be fully disclosed in all plan materials. Now, the good news there, of course, is that there is safe harbor disclosure language contained in the regulations that you can use if you need to amend your plan document. So that's the good news. Okay, so now we're just moving on to the next slide here, which are the key takeaways under the HIPAA ACA rules. The key things to understand here for employers are that rewards, you should really utilize the participatory programs if you can. If you're an employer, you're concerned about incentives, you don't really understand how all this works, you would prefer to keep a very simple wellness plan that doesn't have to calculate anything about the value of prizes or incentives, then you can just use these participatory programs and you don't have to worry about the reward. As long as you make the rewards available to all similarly situated individuals, regardless of their health status. So everyone has to be able to get the gift card for signing up for the class, for example. And of course, the benefit, like we talked about earlier, the rewards for those don't count toward the 30 or 50% maximum. And the health contingent programs, the benefit there is that, the key takeaway there is that you really want to make sure that your plan, if it's health contingent, offers a reasonable alternative standard under HIPAA, and of course understand some of the different rules that apply for activity only versus outcome based that we just talked about. The big takeaway here is, like we discussed with regard to that Honeywell decision, compliance with the HIPAA ACA rules does not guarantee compliance with the ADA, GINA, or any of the other laws that we'll be talking about. So you really have to integrate these rules with the new rules that came out this summer. And so let's talk about those. The key thing to understand about the ADA and the new rules that came out is that the reason why this was so confusing was because there's this general rule under the Americans with Disabilities Act that says that the ADA restricts an employer's ability to make disability-related inquiries or to require employees to undergo medical examinations that are not job-related and and where there's business necessity. So, for example, if for example, if an employer asks about a disability in the workplace, that's a big no-no. If you have a particular job that does not need somebody to, if you have a job like a fire, if you have people who are putting out fires or driving long distances, things like that, they may need to take a job-related business necessity medical examination, but in most cases they should not, because that would violate the ADA. Now, there is an exception for what are called voluntary health and wellness programs. And this was the exception that, I think if you remember back to our timeline slide, back in 2000, the EEOC had tried to explain this exception, but just gave us very little information about what it means. And the good news was that, this summer, on May 16th, the EEOC really fleshed out in much more detail what a voluntary health and wellness program is. First of all, it cannot require participation among employees or discipline or terminate employees based on non-participation in the wellness plan. It can't condition eligibility in or limit coverage in the health plan based on the participation, which is referred to as the gatekeeper rule, but it can provide incentives. So you can do things that look like you're conditioning or limiting coverage by putting a surcharge on employees or adding, giving employees a reward, but you can't condition it entirely. So in other words, you can't say, okay, employee, you have to take a medical screening or else we're not going to let you into our health plan. That's what the gatekeeper rule is. The third thing is that employers can't take adverse employment action or retaliate against employees who don't want to participate, and there are notice requirements and confidentiality requirements as well that have to be complied with. In June of 2016, we received a sample notice, and we'll be talking a little bit more about that. It does have to be sent out to all employees for the plan year that begins on or after January 1st of 2017. So that's an important requirement for an ADA-compliant voluntary wellness plan. Now, the exception, there is another exception to this general ADA rule about prohibiting medical examinations and disability-related inquiries in the workplace, and that's the rule that what's called the bona fide benefit plan safe harbor. This is actually a safe harbor that's been upheld now by some courts that says that you are allowed to condition eligibility in or limit coverage in a health plan based on underwriting, classifying, or administering risks for the health plan, so long as it's not a subterfuge for discrimination. And this is really kind of where we're seeing some of that back and forth between the courts and the EEOC, and that's one of the big reasons for why we are, we'll be talking about that in more detail later. So the next part, the key takeaways under the ADA is that one of the big things, of course, is that these new rules really clarified what the rules are with respect to tobacco cessation programs with or without medical examination. So one of the things that we'll be talking more about in this incentive side of the presentation is really about the tobacco cessation programs. We talked about it briefly, which is that under the HIPAA and ACA rules, you can go up to a maximum of 50% of the cost of the premium for tobacco cessation programs. However, if there is any kind of medical examination or disability-related inquiry in that wellness plan, which could include for a disability-related inquiry, it could include a health risk assessment. For a medical examination, it could be anything from a test for nicotine, something like that. If there's any component like that in the wellness program, then it has to go down to that 30% of the cost of the employee-only tier of coverage. So that's a key difference. We also got some clarification in these ADA rules about notice and prior written authorization. In the proposed rules, prior to these final rules that we got this summer, the EEOC proposed that all employees would have to sign off on this prior written authorization saying, okay, I agree, I'm an employee, I agree that this is a voluntary wellness program before I participate. And the good news is that employers do not have to really worry about this anymore. So, however, they do have to do this with regard to GINA, and we'll talk about that. It also clarified and reaffirmed the EEOC's position against the application of the bona fide benefit plan safe harbor in the wellness context, and we'll talk about that in more detail later. But of course, the real key thing to understand here is this medical examination or disability-related inquiry test, right? If your wellness plan has any kind of medical examination or disability-related inquiry, then you really want to, then that plan is going to be subject to the ADA. So under those rules, the maximum incentive is 30% of, generally speaking, it's going to be 30% of the employee-only cost, the total cost of the employee-only tier of coverage, and you don't have to worry about that 50% rule under the HIPAA ACA rules because it goes under the more stringent rules of the ADA. Now, just like with HIPAA, another big important key takeaway is that compliance with the ADA rules doesn't guarantee compliance with HIPAA and the ACA or with any of the other laws that we'll be discussing. Okay, so now let's talk about GINA. We've talked about HIPAA, we've talked about the ADA, so let's talk about our third of the big three rules for today. And that is the GINA rule. So generally speaking, under GINA, under Title II of GINA, employers are prohibited from requesting or soliciting genetic information. And genetic information includes family medical history. It includes current or past medical information about a spouse, so your spouse's medical information, as well as other genetic information. And so because of this sort of general rule, this is why employers in the past, prior to the rules we got this summer, were so concerned about including spouses in the wellness plan. But of course, like everything else we've talked about today, there is an exception for voluntary wellness programs. So if you have a GINA-compliant wellness plan, then you have, if you want to have a GINA-compliant wellness plan, you have to have a voluntary wellness program. So in order for that to happen, there's a long list of requirements. We're just going to kind of briefly go through them, but some of the big ones are that the employer is allowed to offer an incentive in return for the spouse's medical information, which is the good news. So they did clear a pathway to include spouses in the wellness plans. However, it has to be part of a voluntary wellness program providing health or genetic services. The questions can only ask about the spouse's past or current health status. So you still can't ask about family medical history information. You can't ask about genetic test results. No health or genetic information about an employee's children. And that second point is a really important clarifying rule that we got in these final regulations, was that regardless of the age of the child, you cannot give an incentive for health information about the child. So the best practice here is just to do not include any children in your wellness plan, as it will likely violate GINA. And the incentive rules are really the same as under the ADA. The maximum incentive cannot exceed that generally 30% of the employee-only tier of coverage under the same calculation methods as used in the ADA. We'll talk a little bit about that. There's some slight variations there depending on how the wellness plan is integrated with the health plan. So there's a lot of other additional rules here. The program has to be reasonably designed to promote health or prevent disease. Information has to be provided voluntarily. And here's one of the key differences with the ADA rules. The individual has to provide a prior knowing voluntary and written authorization using a form that describes the type of information that's going to be obtained by the wellness plan, the purposes for which it will be used, and restrictions that apply to that information. Additional rules are that the individually identifiable information can only be provided only to the individual or receiving family member and the licensed healthcare professional. Individually identifiable information cannot be accessible to managers, supervisors, or others who make employment decisions, or anyone else in the workplace. The individually identifiable information is only available for health or genetic services offered by the employer and is not disclosed to the employer except in aggregate terms. The employer cannot condition participation in the program on agreeing to disclose genetic information, and the employer cannot deny health insurance benefits for a spouse's refusal to provide information about past or current health information. So some of the key takeaways here under the new GINA rules are, remember, spouses can participate and receive incentives. That's the good news. And it's also 30% max, so you can offer 30% max to the employee, 30% max to the spouse. Children cannot be included in the program, so do not include children, even adult children, in the program. And the third big takeaway is that You want to make sure that the spouses are providing prior written authorization before participating in the program. And like we've talked about with these other rules, compliance with GINA does not guarantee compliance with the HIPAA or the ADA wellness rules. Okay, so now let's try to tie all this together and really focus in more on wellness incentives, which is really, I think, the focus and really the big question that a lot of employers have when it comes to understanding these rules. So under the HIPAA and ACA rules, you have to have the opportunity to obtain the incentive at least once a year, and the combined rewards for all programs cannot exceed 30% of the full cost of group health plan coverage for the applicable tier of coverage. So for example, if you have an employee participating in the wellness plan, it's the cost of the employee-only tier of coverage, but if you have, let's say, the employee and the spouse are participating, then it's the cost of the employee plus spouse tier of coverage. So that's a key difference between the HIPAA rules and the ADA GINA rules. And then, like we talked about before, you have that additional 20% permitted for programs to prevent or reduce tobacco use, unless, of course, like we talked about, if there's a medical exam or disability-related inquiry. So, for example, if that tobacco program has a medical test for nicotine, then it goes back down to 30% under the ADA rules. But under the HIPAA ACA rules, it can be 50%, and the rewards have to be available to all similarly situated individuals. Now, under the ADA, the plan incentives are allowed if the plan is reasonably designed to promote health or prevent disease, if it's not overly burdensome, if the methods are not highly suspect. So, for example, you can't collect medical information but then provide no follow-up or any medical recommendations. The plan has to be voluntary, like we talked about earlier, those requirements, and incentives generally cannot exceed 30% of the cost of employee-only coverage, with some variations depending on how the plan interacts with the group health plan. So for those purposes, the good news here is that the final regulations gave us 4 scenarios that we can use and rely on. Under the first scenario, if the employee is required to be enrolled in a health plan to participate in the wellness program, then the maximum incentive is 30% of the total cost of self-only coverage. If the employer offers only one health plan, but employees do not have to be enrolled in that plan to participate, then the incentive limit is 30% of the cost of self-only coverage. If the employer offers more than one health plan but does not require enrollment as a condition of participating in the wellness plan, then the limit is 30% of the employee's lowest cost self-only major medical coverage. And the fourth scenario is that if the employer does not offer a health plan at all, so this is where the employer is just offering a standalone wellness plan, then the incentive limit is 30% of the total cost to a 40-year-old non-smoker purchasing self-only coverage under the second lowest cost plan at the silver level on the exchange. So also in the location of the employer's principal place of business. So a lot of special rules there if you have a standalone wellness plan. Another thing to note is that the GINA rules apply these same 4 scenarios to the same ADA incentive standards to as GINA incentives as well. So you also can use 30% for the spouse. So let's try to now kind of tie this all together and look at 2 examples of what would be a HIPAA ACA compliant wellness plan, but not an ADA GINA compliant wellness plan. So this first example complies with the old rules, but does not comply with the new rules. And then we're going to look at one that complies with both sets of rules. So I did want to briefly mention, before we go on to this section, a little bit more about that July 1st guidance that came out, that informal discussion letter that we got from the EEOC on multiple group health plans. The key takeaway there, and we did a Compliance Minute episode on this, so you'll be seeing that soon, but the key takeaway there is that the EEOC recognizes that their new rules that came out this summer don't perfectly comport with the HIPAA ACA rules, and there's certain areas where you're going to get different results, based on the fact that the rules are different. However, in the EEOC's view, they believe that that was necessary to ensure that the wellness incentives weren't going to become so high as to become coercive. So that was kind of the key takeaway there. Okay, so let's look at this first example. So as you look through, so here we have an example of a 5,000 life employer with monthly employee-only full premium rate of $500. The employees pay $250 per month, but they can reduce that to as low as $20 through the incentive. So as you can see, that's they're allowed to go all the way up to 50% reduction of the premium by complying with all of these elements of the wellness program. And if you look at the different elements of the wellness program, you see that there are actual medical examinations and disability-related inquiries involved here, because you've got the participation in the HRA, you've got a blood pressure test, you've got a blood glucose level test, as well as blood nicotine use. So all of these things would be medical examinations. So these things would fall under the purview, of an ADA. These things would be regulated by the ADA regulations. But before we got the final regulations, this would be a perfectly compliant plan, because since if you look just at the HIPAA ACA rules, you'll see that because it had that tobacco nicotine component, you could add an additional 20% to the total incentive, and you could go all the way up to 50% of the total premium. So this would be a perfectly compliant HIPAA ACA plan, but because you're going over that 30% threshold, this would not be compliant under the ADA and would not be compliant anytime after January 1st of 2017. Now let's look at an example of one that's both HIPAA ACA compliant and ADA GINA compliant. So here you have a 5,000 life employer with a monthly employee-only full premium rate of $500. Employees pay $250 per month, but can reduce it to as low as $100. So they can get $150 off, which is just at that 30% threshold of the $500. And if you look at each of these elements, so you have the same tests as we saw in the last slide, so definitely medical examinations happening here, definitely disability-related inquiries, and when you add it all up, it adds up to 30%, so this one's the kosher one under the new rules. Now I do want to talk a little bit about confidentiality and the importance of maintaining confidential health information, because it's so central to these new rules that we got this summer. And I thought this photograph really did a good job of illustrating kind of the importance of why health information is so important. As you may know, Charlie Sheen paid people millions of dollars to pay them off so they would not disclose his HIV status. So this is a kind of a funny or interesting picture that illustrates that. But of course, as an employer, the penalties can be monumental, also in the millions of dollars if there are breaches of confidential health information. So the question I think that so often asked is, well, what are employers doing to ensure that the health information will be kept confidential within the wellness plan? And there are a number of different things employers can use. They can use encryption, they can have written policies, and use third parties. But the three main things that are required under the ADA rules are that you can only provide medical information to employers in the aggregate form and not disclose the individual identity of the wellness participants. The employer cannot sell, transfer, exchange medical information except to carry out specific activities related to the wellness plan, and the employer can't require employees to waive their ADA confidentiality protections as a condition for participating or receiving incentives. Now, we did get some additional information about what employers can do to comply with the notice and disclosure requirements of the ADA in June of 2016. The four things that are important that employers have to do under the ADA is to provide a notice to all of their employees that are eligible to participate in the wellness program of what medical information will be obtained, how it will be used, who will receive it, and the restrictions on its disclosure. So those are the big four requirements. Now, the good news is, of course, there's that sample notice that you can download from the EEOC website. We did an e-alert about that with a link to the sample notice. And the guidance that came out at the same time clarified that the notice requirement applies regardless of the group health plan. It's effective for plan years beginning on or after January 1 of 2017. And like we talked about before, this is not a requirement to have a prior written authorization, so there's nothing here for an employee that they have to sign off on necessarily. But it is important that the employees have this notice and that they receive it. And the other thing that we learned from this guidance that we received in June was that employers can customize this notice and change it around a little bit, so long as it has those four main requirements on the left side of the screen there. So now I want to talk a little bit more about the gatekeeper rule and this bona fide benefit plan safe harbor, which I think is causing a lot of confusion among employers, and particularly all these things came out in this recent decision of EEOC versus Flambeau. And to give a little bit of background on this case, without going into too much details, the key facts to know are that the EEOC sued an employer after the employer terminated an employee's coverage under a self-insured medical plan for not completing the wellness plan's HRA in a timely manner. And completing the HRA was a condition to coverage in the medical plan. So the EEOC argued that this wellness plan violates the ADA. This is not a voluntary wellness plan. This does not comply with, doesn't comport with the rules that we've set out. The employer argued, no, this is actually an exception to the ADA requirement. It qualifies as a bona fide benefit plan safe harbor, and it was a voluntary plan. The reason why it qualifies for the safe harbor is that we were using this HRA and completion of the HRA as a way to identify health risks for underwriting purposes prior to letting people into our health plan. So this should be perfectly okay. And they cited to an earlier case, Seth versus Broward County, which had upheld the bona fide benefit plan safe harbor. And then, of course, much to the surprise of many of us in the benefits community and those commenting and writing about these types of things, the court in the District Court of Wisconsin actually said, okay, employer, we agree with you. We believe this qualifies for the bona fide benefit plan safe harbor. While the court did not decide on whether it was a voluntary wellness plan, it did say that the employer wins, that this is okay. Of course, right afterwards, the EEOC challenged this because it was in direct contravention of what they had said about the gatekeeper rule in their regulations. If you remember, both in their proposed and final regulations, the EEOC said you can't have a gatekeeper, you can't use the wellness plan as a gatekeeper on your health plan and make employees participate in particular tests before they can be enrolled in the medical plan. So as we know, of course, the EEOC reasserted its position in the final regulation. It appealed the decision to the 7th Circuit Court of Appeals. And the recent breaking news that we have that came out after we had finalized the presentation and uploaded it into our system was that on September 15th, the 7th Circuit Court of Appeals held oral argument in the case and really expressed a number of doubts during the oral argument that this case has any jurisdiction at all, because they said that they didn't really think there's really any kind of damages here. So they said, without some kind of determination that the employee suffered an economic loss, emotional distress, or some other damage, one of the judges opined the case likely constituted much ado about ancient history. So prior to that, I think a lot of people were thinking this might actually go all the way up to the Supreme Court, but in fact it may actually get dismissed because for lack of finding any kind of damages against this employee who couldn't get into the medical plan. So interesting case. But the real takeaway here is that it's best to play it safe, right? You don't want to be, it could still go up to the Supreme Court, so you don't want to be the employer that is the test case for that, and that takes it all the way up to the Supreme Court. You want to comply with the final regulations, make sure you're not using your wellness plan as a gatekeeper to your health plan, even if that safe harbor applies. So let's talk a little bit about the Affordable Care Act and tax penalties, that some questions that we often get when it comes to designing wellness plans and wellness plan incentives. One question that comes up quite often is, will these incentives make our coverage unaffordable under the Affordable Care Act? And if you remember from our earlier presentations we've done, the Affordable Care Act generally requires that coverage has to meet the standard of MEC, or minimum essential coverage, it has to meet minimum value, and it has to be affordable, generally speaking, in order for employers to avoid a penalty under the ACA. And the question, of course, about affordability is that if the coverage, the cost of employee-only coverage is too high and it exceeds a certain threshold, then employers can face a penalty. So this question comes up, and well, what impact will our wellness incentives have on this ACA affordability requirement? Well, the good news is that incentives, well, whether you look at it as good or bad news, generally speaking, it makes things easier, is that the incentives do not really count. So if for every kind of different wellness plan incentive that's offered, wellness plans will not reduce the amount of the employee's required contribution for purposes of affordability. So, if you think it will reduce the contribution, it won't. So it's not going to make your plan more affordable if you give an incentive, with the only exception of tobacco use. So if you have a wellness plan that offers, so if you a tobacco cessation program or a special incentive just tied to tobacco use, then that amount can be used to reduce the employee's required contribution for purposes of affordability, and it's just treated as if it was actually earned. So every employee will get that amount regardless of whether the employee actually qualifies for the incentive. The other question that comes up quite often now, and we saw some guidance come out at the end of May on this issue, is are we double dipping? And the key takeaway here is that we got this Chief Counsel Advice Memorandum at the end of May, and it said an employer cannot exclude from an employee's gross income reimbursements of premiums for participating in a wellness plan if the premiums for the wellness plan were originally made by salary reduction through a Section 125 cafeteria plan. So what that means is if you already got the pre-tax benefit of paying for it through the cafeteria plan, you can't make it tax-free on its way out, going back out to the employee. So if, the other thing that the memorandum clarified too is that cash rewards that are offered under a wellness plan have to be treated like other cash or cash equivalent benefits provided to employees. They are considered to be taxable compensation. Now there are some exceptions to that. Things that are not that are not required to be taxable compensation, like for example de minimis fringe benefits. So for example, if let's say you have a course like an employer-sponsored wellness webinar about reading food labels, for example, and everyone that participates gets a pencil or a T-shirt, then the value of that pencil or T-shirt is likely to be considered to be a de minimis fringe and will not be considered to be taxable compensation. Of course, that's something that a lot of employers have questions about, and it can get a little complicated. So we definitely, definitely it's always good to speak with your tax advisors when it comes to those types of questions. Now, wellness plans are subject to COBRA. We talked about that earlier, but how does that work, right? Well, if the wellness plan is offering medical care as defined under Code Section 213D, then it will be considered to be subject to COBRA. And I think this is a little confusing for employers because I think a lot of employers think, well, I didn't do a notice requirement for so-and-so, and was I supposed to? Or well, it should be noted that an employer is allowed to combine their wellness plan with the employer's major medical plan and do one COBRA notice for both. So that's the good news, but you should exercise some caution here because there may be some hidden costs that you're not really aware of. So for example, let's assume you have a wellness program that provides a medical benefit. So it provides, let's say, flu shots, or it's doing something that's, maybe it's testing nicotine, it's doing a smoking cessation program where it's, really providing some kind of medical plan or medical benefit, and therefore it constitutes medical care under Section 213D, and it's subject to COBRA. And let's also assume that to encourage a healthy workplace, an employer decides that all employees, not just those in the major medical plan, are eligible for the wellness plan. Let's just say the COBRA would apply to the wellness program, as we talked about before. So all the individuals who elect to continue the wellness plan under COBRA are going to be able to take advantage of an open enrollment that occurs during their continuation period. So that's something that a lot of employers don't think about. So for example, if you've got a group of COBRA qualified beneficiaries who are just wellness participants, and now they're on their COBRA continuation period, and during that COBRA continuation period there's an open enrollment period, then they have to be able to elect any type of coverage that any other employee would be able to elect. So they could still elect to go on to the major medical plan, and that could present a risk or a significant adverse selection risk for employers if they're not cognizant of that possibility. Okay. So there are still some questions that we didn't get. There are some lingering questions that we didn't get answers to in the final regulations. And I thought I'd just kind of briefly go through some of the big ones. One of the big ones, of course, is how do we value raffle prizes, like an expensive cruise vacation. Of course, we don't know. It's not in the regulations. Do you divide it by everyone who is eligible for the raffle? Do you buy the total cost? You just do the total cost of the cruise vacation. If it's thousands of dollars, it could easily go over the 30%. Our recommendation would be conservative there. The other big question that was not answered is, what if we have multiple wellness plans? How do we calculate the maximum incentive? So the rules address multiple health plans, but the rules do not address multiple wellness plans, right? So let's say, for example, you've got a HIPAA ACA wellness plan that says, just requires you to sign off on an affidavit, no medical examinations in that one, but then you've got another wellness plan that's got, blood tests for nicotine, all kinds of medical examinations. Well, the safe way to go about it would be to act as if all of the incentives for all of these different wellness plans and programs are all combined, and if any one of them has a medical exam or disability-related inquiry in it, then you want to make sure that all of the incentives combined do not exceed that 30% max threshold under the ADA and GINA rules. So I think that's the cautious way to go, since we don't have any clear answers on that. The other question we often kind of get, not too often, but it comes up every once in a while, is should our company continue to offer a day off wellness incentive, a paid day off? And I think the answer to that really depends on the value of that paid day off for the highest income worker. The final regulations clarified that the value of in-kind incentives will be calculated by the agencies, but they didn't tell us what the method would be for for doing that kind of valuation. So it's possible that if you have a very high income worker, then the paid day off could exceed the 30% threshold. So you really need to be careful with those paid days off. And since we're running low on time, I'm not going to go through all of these recent developments that we've been writing about and speaking about, but we do have a very helpful list here of some of the things that we've recently drafted articles and e-alerts on, and we would encourage you to take a look at our recent e-alerts on these topics, as well as our Compliance Minute videos. And that's it for today. We will try to answer your questions. Sometimes we can get over 100 questions, so we'll try to get to as many of them as we can today if we weren't able to get to them during the presentation. And with that, I want to thank you for joining us today.
Great information, Dan. Thank you. SHRM, PDC, and HRCI credits can be downloaded now by clicking the yellow document icon to the right of the widget bar on the bottom of your screen. As you exit the webinar, please take a moment to complete the brief questionnaire that appears so we can address any feedback that you have for us. Any further questions can be sent to me. That's dina.beck@corpsyn.com, dina.beck@corpsyn.com. Thanks for your attention, and please enjoy the rest of your day.